Welcome, everyone. This presentation, I'm going to move through matters somewhat swiftly because, as you can see, there is a lot of material to cover. So I just want to start at the beginning. I know this may sound like basics for some things, but this is an overview of evidence. Evidence begins when you take the case in. It starts at the very beginning based on the facts and your theory of the case. Think early on in your case, what are some of the primary issues you will be dealing with, and how to work those into your strategy. For example, when you do your consultation with your client, are there separate property issues that you know are going to come up? Is there a prenuptial that you need to locate and interpret? Those are much more common these days. Are there going to be issues of commingling of assets, transmutation of separate property? Because these are going to inform your discovery, which is going to inform your evidence. So when we say evidence, evidence isn't just what happens in the courtroom. It is what starts at the beginning of your case and flows through your entire approach. So don't neglect to think about that up front, and always keep a list of the issues you're going to have to tackle, because the question becomes, who has the burden of proof? And the burden of proof informs the discovery you're going to need for the evidence you're going to need. If you know there's been, you're going to argue there's been transmutation of separate property into marital property, do your research. Who bears the burden of proof, and what are you going to need to prove or to defend that kind of an argument? Okay, so starting with discovery, which is where evidence starts. Again, this is the basics, so I'm going to move through this somewhat swiftly and stop and highlight on tips and techniques. As you know, the basics and the techniques in discovery in matrimonial actions are governed by the CPLR. If you're in family court, that's different. Those are special proceedings. Those are governed by the Family Court Act. And you need permission of court for most discovery in family court. But in Supreme, in a divorce action, you're governed by the CPLR. Keep it on your desk right next to you. It is one of the most precious documents. Common tools. I recommend that here's a tip, unless you need to start serving discovery immediately, maybe you need to preserve some issues or some documents. I usually recommend you at least start with exchanging your statements of net worth first, because what is on that statement of net worth, again, is going to inform the discovery that you need. I share those statements of net worth with my client, their spouse's statement of net worth. I go over it with my client, ask them, what do you see? What do you not see? Your client knows the family finances much better than you do. Utilize your client in digging through that document to figure out what discovery you may also need. But if you need to launch into discovery right away, there's nothing wrong with doing that. Discovery is an ongoing process. The demands usually have a statement at the end that says this is an ongoing demand. You don't just give me what you have today, you give me what you discover a month from now or even a day before trial. If it's demanded, it's an ongoing requirement to turn over those documents. Also, in many summonses for divorce that you see now, in addition to all the mandatory restraining orders that are in there, many of them also have a preservation of evidence notice right in the summons, which immediately, without having to serve discovery, puts the other side on notice that they have to preserve any evidence. They can't destroy social media postings or documents, etc. Okay, so common tools, obviously witnesses, who are going to be the witnesses, fact witnesses, who are going to be your expert witnesses. Those are not always discovered immediately. You may not know that there's an issue that requires an expert. You may assume this is a basic case, it won't need one. Ask for it anyway. If you don't ask, then there's no obligation to tell. Of course, we'll get to this a little bit later, but be aware of the NYCRR rules about experts and reports that have to be filed pre-trial. There are time limits on those, so do keep an eye on that. You may want to demand school records, medical authorizations, therapeutic authorizations. You can just serve a demand for authorizations or an authorization to Bank of America for records between X and X. So with your discovery demands themselves, you can also attach specific authorizations and have the other side fill in information, social security number, bank account number, or whatever. Realize if you're going to demand records that are medical or therapeutic, that they must be accompanied by a HIPAA release signed by the patient, or the medical or therapeutic organization does not have to respond to those. Social media posts and preservation of evidence of social media posts, you can request those. Interrogatories, they're not that common, but they're sometimes a very good technique for getting information. Remember, interrogatories are answered under oath. They're written, but they're answered under oath. So that has the benefit of being able to have something to potentially impeach someone with at trial. And in addition to asking for answers to questions, it can also demand documents in support of those responses. So they can be very, very helpful. I want to highlight the notice to admit. This is very important. It's going to come up a few times through this discussion. The notice to admit is a wonderful document. If you know that there is something in dispute, maybe there was a prenuptial and the original has gone missing, and you want to send a notice to admit to the other side to admit that this is a copy of the original. That would be very, very helpful, and that could avoid the problem of not being able to find the original. Or maybe there was some kind of bequest or other documentation that could help authenticate something related to a separate property claim. Don't hesitate to attach a document to a notice to admit for authentication, or just basic facts. There may be some very standard facts that if you could get them admitted early on, will save you a lot more discovery. It'll save you depositions. It'll save having to make motions. Think about using that early on. It is extremely helpful. And failure to deny the content of a notice to admit is deemed an admission. So maybe you have a slow, lazy opponent who isn't paying attention to discovery demands, tosses it aside, and time has gone by. They haven't denied it. A month has gone by. You've given them plenty of time. Those documents or those facts are deemed admitted. So be very careful. Also, when you get served with discovery demands, make sure you mark the date for when they're due. I know a lot of people say, well, you know, it's discovery's loosey-goosey in family court actions. It says I have 20 days or 30 days. No big deal. I suggest you put these things on your calendar and don't let them pass by. You might have a judge who's very strict about discovery. And it's always best and courteous to send a note and say, look, you know, I don't have all the documents. Here's what I have. Or would you give me another 30 days? But don't just blow the dates off. I think it's bad form. You can also request to inspect property. You may have a case where somebody has a store and there is inventory that you think will disappear, or records that you think will disappear. Too many cases I have with stuff in safes in people's homes. You can serve a request for property examination. And of course, as I'm sure you're aware, physical and or psychological. If there is a custodial issue, there are psychological or forensic examinations, and then physical if there's a claim of disability, perhaps. That's all open season in matrimonial actions. Okay, objections to discovery. There are time limits under the CPLR for objecting to a discovery demand. Make sure you know them. If a demand is served on you and you believe it is asking for inappropriate information, it's overbroad, it's requesting privileged information, it's overly burdensome to produce, the burden is on you as the recipient of the demand to set forth that objection timely. If you do not set forth that objection timely, it can be deemed waived. If you set forth the objection, the burden then shifts to the person who proposed the discovery demands to then come forward and explain why it's not privileged, why it's not overly burdensome or broad. So again, pay attention to the time limitations. You may need to move for a protective order and request that some of the information not be turned over because it is confidential, or perhaps it gets turned over, but it needs to be redacted. You can move for a protective order. Certified business records, we'll talk a little bit more about that under subpoenas, but be aware of the weight of a certified business record and its ability to be admitted into evidence. One of my favorite, most recent statutory sections to come out in the last half dozen years or so is 4540A. That is the authentication rule. I'm sure many of you know about it. It was really made discovery and evidence much easier. The documents that you produce on behalf of your client, that your client gives you and that you turn over in response to a discovery demand, are deemed to be authenticated for the purpose of allowing your opponent to introduce them into evidence. And of course, vice versa. If you demand discovery of your opponent and they produce a bank record, then you are entitled to introduce that as an authenticated document at trial because it was produced by the other side. The assumption being, if the other side produced it, they shouldn't have a right to object to it at trial, saying it's not a true document because you produced it in response to my request for a true document. It's logical, but they finally codified it. So be aware of that. The effect of the refusal, we'll go on to the next screen, Taylor. I think this topic may have gone to the next screen. The effect of the refusal, no, we're on, okay, I'm sorry, go back one. We're still on discovery. The effect of the refusal to comply with discovery. If your opponent has failed to respond, send a good faith letter and request, obviously, before you do anything else about it. If they have, and let them know this is a good faith effort to get compliance. If they still refuse or fail to comply, pick the phone up, you talk with them, it's clear documents are not coming. You can make a motion to the court to compel production of the documents. Under CPLR 31, 24, 25, and 26, there are several things you can do. Move to compel them to produce. If they don't produce, you can ask in the alternative that the court preclude them from introducing the documents at trial. If you're not going to give them to me, you don't get to bring them into trial. You may want to be careful about asking for preclusion because you may really need these documents to prove your case. So maybe you don't want to move to preclude, but to compel. And there is also relief asking the court, if they don't produce the documents, then I want the issue at the heart of these documents to be determined in my client's favor. So a directed determination as to what that evidence would have proved, because there's some reason you're not producing the documents. You can ask for dismissal of all or part of a party's claim as it relates to that document, those issues, whatever you're looking for. Also ask for legal fees. That is very common. If a court believes the other side has improperly failed to comply, they can grant your client an award of legal fees for the work you had to put into getting this done. So be aware that you can make a motion for any of these things. And conversely, your failure to respond to discovery could hurt your client the same way. We've all had clients that either don't want to produce documents or simply can't produce documents. They're a bad record keeper. There are other ways to respond to discovery if you don't have the documents. Contact counsel, tell them I'll give you an authorization, or my client will go to the bank and get them themselves. And discovery isn't just what does your client have in their house. Are the documents in existence? If they are and you have them, produce them. If they're in existence and you don't have them, then go get them. If they're in existence but you're unable to get them, then respond that way and produce either an authorization or tell the other side we'll cooperate with a subpoena to get them. We won't object if you have to seek a subpoena. So that moves into the next topic, and you can go to the next screen. Subpoenas. When are they needed and how are they used? Again, I give you the citation to the authority for that. with or without court authorization. So if this is a subpoena for trial, either for a witness to come to court or to produce documents at court, unless that witness is a municipality or the records you want come from municipality, you can issue a subpoena as counsel to the witness, and you can ask the witness to bring documents with them. You can issue a subpoena to the opposing party. Nothing wrong with that. Even if you don't call them directly as your own witness, you can issue a subpoena and ask them to produce certain things. Don't use that as a last minute handicap for the fact that you didn't seek discovery timely before, but you can do that. If, however, and so it can be a witness subpoena or it can be a ducis tecum, a production of document subpoena. You want some records from the bank, you want some records from the employer produced. And if those records are authenticated, if they're certified, when you serve the subpoena, you serve a request that they be certified, and there are sample certifications you can send. The people just authenticate them, produce the employment records for the defendant, and sign the certification, then those will be admissible in court at trial. So it can be a witness subpoena for a person, it can be a document subpoena for records. However, if the records are being requested from a municipality, a county hospital, a school district, somebody works for the state of New York, their employer is a municipality, you are going to need to get a judicial subpoena. It must be signed by a judge. These are required to be done on motion. Sometimes, if both sides agree that these documents are necessary, or both agree to have them produced, some judges will sign a subpoena on consent of both sides. If there is no consent of both sides, however, you're going to have to make a motion to the court. What records do I want? Why do I want them? Why are they relevant? I have attached a sample subpoena and motion to the handouts that you have that can be changed up and used for any variety of requests. But note the CPLR sections for the motion, service obviously on your opponent, and service on the municipality, again, is governed by CPLR 2306. Read that. If you're asking for records from a city, who gets served? If they're from a county, who gets served? If they're from a state agency, who gets served? Make sure you serve the proper parties. The motion must be on notice to opposing counsel and on notice to the party you're seeking to serve, so they can make a motion to quash or object or to limit the records. So go through the statute and follow it very carefully. And don't forget that there are costs and fees that go along with serving these subpoenas. If they have to come to court, there's mileage. And then there is the standard statutory fee, which goes up every few years. So check to make sure you're serving the subpoena with the proper check and fee. This goes for all subpoenas. I also want to highlight, where are the documents returnable? If it's a witness subpoena, it's irrelevant because the person's showing up in court. But if it's a ducis tecum document subpoena or a judicial subpoena for documents, where are you having the documents returnable? Many subpoenas issued just by an attorney. I want bank records or credit card records. Most of those will be returnable to the attorney directly. But sometimes the attorney will ask that they be returnable to court. If they are returnable to court, you have served a copy of the subpoena on your opponent. Your opponent knows that the documents are returnable to court. When the documents are produced in court, you do not need to send copies to your opponent. They can go to court and see them on their own. However, if the subpoena makes the documents returnable to your office, you are then obligated to provide copies of the documents to the opposing party. Okay. Moving on from subpoenas, let's talk about preparing the witness, because so much of evidence, we focus on documents and objections to documents and how to get them admitted. But one of the primary pieces of evidence at trial is your client or your witnesses, not just your client, but any other witnesses you call. It is a big part of the evidence, and it's often overlooked your client testimony is key. So again, I just want to run down a few tips and highlight a few things here. Many of us have gone to court when it's clear a witness has not been prepared, and we don't want that to be our clients who walk out saying, why did that happen? I didn't know you were going to ask me about this, or I didn't know I was going to be questioned or recalled to the stand. So here's just a punch list for you. Do close and aggressive questioning of your own client. Get them into the office, not just the day before, get them in weeks before, and then give them time to digest and bring them back in later. Do close and aggressive questioning. I know some lawyers that even will, type out a little list of topics they can go over with the client to give them to think about. But do sample questioning of them. Sit down, talk to them about their body language. Do they have fidget habits? Is this somebody who hesitates too much? Do they stutter? Prepare them and make them comfortable with being questioned, and don't softball them. Ask them very aggressive questions. Find all the skeletons in your client's closet and get them out in advance. If your client is a stutterer, have them say that right up front. If your client's a fidgeter, have them address it. If your client's a crier, some people cry on the stand, especially in divorce cases. Get that all up front and begin to talk to your client about how we're going to deal with it. Let's not make it a handicap. Let's take it to our advantage. Do sample direct and cross-examination. What I tell my clients is direct is friendly fire, and cross-examination is enemy fire. Do the enemy fire. Ask them very direct questions. Even if you know your opposing counsel's the nicest person and they're never going to get aggressive a little bit with your client, because you don't know what's going to happen. You don't know if the judge may lean in and ask questions, or if there's an attorney for child. But do the cross. I do what I train my clients in what I call the 3 count rule. I say, when you're asked a question on cross-examination, count in your head to 3, 1, 2, 3, then answer the question. And what I tell the client is the reason for that is twofold. One is to give you a moment to actually focus on the question that's being asked, not what you think they want. Focus on the question being asked. And I tell them, because I need time to listen to the question and decide if I want to object to protect you from the question for any reason. So give them a moment to focus on it. And we all know the standard question we ask a client to prepare them for cross-examination. We say to our client, opposing counsel gets you on the stand and says, Mr. Smith, do you know what time it is? If your client looks at their watch and says it's 12:25, you tell them that's the wrong answer. The answer is either yes or no. And that simple example, we all know from the basics, clicks in your client's head. Don't assume they have not done this 100 times like you have. Okay, explain the objection procedures. Law and Order has been on for 25 years, but a lot of people still don't know that sustained means your client does not have to answer the question, and overruled means they do. And when they're in that anxious seat up on the witness stand under oath, it may not process. Sometimes I have to actually look at my client and say, that means you can answer the question, but prepare them for that. What does it mean? And that when the judge does that, the judge isn't mad at them. The judge just wants them to be protected also on the record. Explain redirect. I find that a lot of people are not told that they can be called back to the witness stand for redirect, that there's direct examination, friendly fire, cross-examination, enemy fire, but then there's redirect. It'll put your client or the witness at ease to know that if after they've gone through cross-examination, they feel they've given a bad answer or they didn't answer the way they really wanted to, now for the rest of the cross-examination, they're just focused on, oh my God, I shouldn't have worded it that way. It was taken wrong. And they're not focusing on the rest of the questions, and then the rest of the testimony is just horrible. But if they know that you're going to be able to come back and redirect, re-question them on the things that they were cross-examined on, that gives them a little bit more of a sense of peace, because I tell my client, look, don't worry if you think an answer came out bad. I'm taking notes. I'm paying attention. I'm going to have a chance to come back and let you explain. And that puts them at ease and makes it a lot easier. That one little thing, many witnesses are not told, it's going to make a big deal. Warn your client that opposing counsel can call them as a witness. Very rarely are clients warned. You get into court, it's a day of a trial or a hearing, and you're the defendant and the other party calls your client to the stand. Your client's freaked out. What the heck is going on? You're not my lawyer. How come you get to question me? If you haven't prepared your client for that, the whole thing's going to be a mess, because they're just completely off kilter now. And as an opposing counsel, that's a great way to throw your adversary off kilter. But if they're prepared for it, it's not going to work. So warn them that opposing counsel could call them as their witness. But as most of you, I'm sure, know, the result of that is that they cannot then seek to impeach their testimony, because if opposing counsel calls your client or your as a witness, they're vouching for the veracity of your client. That's the general rule. Simplify language. Tell your client to use simplified language. Your witnesses, especially if they are expert witnesses, you have an expert testifying on the value of a used car business, tell them it's used car businesses for dummies. Don't use any industrial language that you can't easily explain or break down in simplicity. And warn the witnesses not to fence with counsel, particularly in divorce. The wife's attorney or the husband's attorney or the spouse's attorneys don't like the other attorneys because they identify them with the enemy, unfortunately. And so there's a natural anger or aggression or dislike. And there's often a desire to prove that they're smarter than the attorney. Tell them not to fence with the lawyer. The lawyer has done it hundreds of times. They have not. And all they're going to do is get the judge to look at them in a skeptical way. If the lawyer's going to be difficult or abusive, then your client will have a little bit of a badge of empathy from the court. Get the bad stuff up front and own it. If you know your client's going to testify, maybe it's a custody case and your client has a past alcohol abuse history or something of that nature, get the bad stuff up front and own it, regardless of what it is. And conversely, have your client also be able to say something positive about the other side. Let's face it, they were married. Even if it was a short-term marriage, there's a reason they married. It was an intimate relationship. If there was something decent about the spouse, no harm in putting it out there. They have a lot more credibility that way because the world is not black and white. Coach your client on watching their body language when they get up. You may have someone who, chips at their nail polish all the time or wiggles a bit or blushes or whatever. That may be natural and that's okay. But if you've prepared your client, you've prepared them to know how to use it. But just watch their body language. And of course, when someone else is testifying on the other side, note the body language. It makes a difference. Watch the judge and tell the client that the judge will be watching them. Even when someone else is testifying and your client's at the counsel table next to you, I tell my client the last thing you want is your eyes rolling, huffing and puffing and slamming the table when an answer comes down. That is really important. And as most of you know, on custody appeals, if there's an issue of custody in your case on custody appeals, the appellate courts heavily defer to the trial courts. And a lot of the language in the decision says because the court had the opportunity to observe the behavior of the parties. That is very important. Okay, last tip on preparing witnesses, the notepad theory. Many of you who've been through trials before know that the most annoying thing is you're at the witness table, your client's next to you, at the counsel table, your client's next to you, and someone is testifying, and you're trying to listen to the testimony, and you're taking notes, preparing for cross. The last thing you want is your client tugging on your shoulder, whispering in your ear, he's a liar, that's baloney, and just telling you facts and things that you cannot process through both ears at the same time. I give my clients and I tell them in advance, here's a notepad, here's paper. I cannot listen to two people at the same time. I cannot process two at the same time. I need to listen, take notes. If there's something going on, there is something that I need to know for cross, something they're saying, maybe they're facts we haven't discussed that just came out for the first time, and your client is anxious, give them a pad and paper and tell them to make notes. And I tell them writing, she's a big fat liar is not a helpful note for me. Write a note that is specific to what's going on so that I can then regroup, prepare for cross, and go from there. As many of you probably know, there has been a website put together for the New York State Rules of Evidence. I gave you the site there, newyorkcourts.gov, Guide to Evidence. And there's also, I still keep at my desk, Thomas Mowat, The Fundamentals of Trial Techniques. It's not that big a book, and it's just got really good step-by-step ways to get things into evidence. They're just two really wonderful resources. Okay, we are halfway through. We're doing good.
Since we're halfway through, let's take a moment to pause, and I'll read off the first course code. So for everybody, the first course code is going to be 943816. Again, that's 943816. And I'll leave this up for everybody for a moment. All right, I will be moving on to the next slide, Barb.
Okay, thank you. Okay. All right, so introducing the records, actually getting them into evidence or keeping them out of evidence. That may be what you want to do. Again, circle back to what you need to prove your case, because you've analyzed this at the beginning. You've been working on it through the discovery. Make a checklist. On the issue of separate property, this is what I need. On the issue of imputing income to the other party, this is what I need. So categorize things and begin going back and going through your documents and figuring out, what do I need to have marked in evidence? Standard things, the statement of net worth, the tax returns, the W-2s or pay stubs. Get them all marked, the basic things. Make a list of the exhibits and what the judges love. And again, these are bench trials. There's no jury, so the judges love it streamlined. Is many of these judges will have had a pretrial conference and perhaps given you deadlines for submitting witness lists, submitting exhibits. Some judges don't. Act as if that's how it's done, because that's the most efficient way to prepare your case. But if you can stipulate to exhibits with your opponent, do that. Make a list. What I do is I make a list. I'll send it over to the other side. I'll say, these are the documents that I would like to introduce into evidence. Let me know which ones you agree to stipulate. Subject to cross. Just because we're agreeing to put them into evidence doesn't mean we're not going to question our clients or the other side about them. So it's subject to cross. You're not losing any rights except the right to keep the document out of evidence. But maybe out of a list of 22 exhibits, my opponent will say, okay, I only disagree with these 3. Now I know that these are the 3 that I'm really going to have to work hard to get into evidence. And maybe I've known that all along, but I'm going to have to be extra ready because I know where my battleground with my opponent is on my evidence. So it serves the purpose of helping organize your evidence, making it easier for the court, and identifying where your problem spots are really going to be. And then I invite my opponent to make a list of the documents they want to introduce into evidence, subject to cross. I'll go through the list, say I agree to these 20, I don't agree to these 3. And now we know what we have to deal with. Pre-mark the exhibits if you can. Again, even if there is not a pretrial order, pre-mark them. Bring 3 sets at least into court, a set for the judge, a set for your opponent, a set for yourself, and maybe even a 4th set to just use to hand to witnesses, so you don't have to give up your originals. But pre-mark those and get them ready. When you get there, the steno is going to be so happy. All they have to do is put stickers on them and put them on the record. So now you know what items you're going to have trouble getting in and you can plan for them. Perhaps you need to be ready with some case law. Maybe you need a memorandum of law. If you knew that a particular item was going to be a real battle, you could make, I don't have it on the list here, but you could make a motion in limine prior to trial. I know that I'm going to have a really hard time getting this particular document in. Opposing counsel has already told me so. They denied it on my notice to admit. Maybe I want to make a pre-trial motion relevant to this particular piece of exhibit or this particular witness that I want to use. And maybe I need a memo of law to go with the motion, or maybe I don't make the motion, but I know I'm going to at least have some case law at hand to say, Judge, this is why this is admissible. I know my opponent objects, but here's Smith v. Smith, and this is why it's admissible. Be prepared. Judges don't get insulted when you give them case law. And if you say, Judge, I do have some case law on the issue, if you don't mind, and if they mind, they'll tell you. And if they don't mind, and most of them won't, they'll be more than happy to look at it, have a copy for your opponent. Your notice to admit would have helped either overcome or anticipate these objections. That's why it is such a useful item early on. Subpoenaed documents, again, if they're certified, they're easily stipulated too. Making the judge's job easy is really going to go a long way. I don't know how many of you practiced in Schenectady County, and he's passed away now, but Judge Vincent Riley, he used to tell me when we were doing trials, he would say, the object of his trial is for the lawyers to get that big stack of documents off their desk and onto mine. And that's really it. That's the purpose, is to get our evidence into the judge's hands so that they can make the right decision. Just make that job easier for the judge if you can. Know what battles to fight. Hopefully your clients have considered this along the way. You've considered it. If the issue you're fighting over is the difference of $5,000 and litigating it's going to cost your client $10,000, that's what we call a bad return on investment. So work with your clients, guide them along the way, do a cost analysis for the issues you're fighting over, and decide where to really put your time and your client's money when it comes down to it. I have provided in the handouts there some sample questions for getting some common exhibits into evidence, but things that come up a lot these days, like texts and social media and recordings. Again, that Thomas Mowat book, even though it predates social media, all of the techniques have translated into what we deal with today. And so have that ready. And you know what? If you haven't done this a lot and you need to throw a cheat sheet in the back of your folder, here's the questions I need to ask to get this exhibit in. Do it. There's nothing wrong with that. Know your best evidence rules. And here, best evidence is the rule. It simply requires the production of an original writing where its contents are in dispute. That's the key. If the contents of a document are not in dispute, you don't have to produce the original. If it was produced on discovery, it's been authenticated by the other side, or if you have served that notice to admit because you think there might be a dispute. You'll know early on if you've used your discovery techniques properly. It's only where the contents are in dispute that the best evidence rule is really going to become an issue, like that prenuptial that nobody was able to find. Offers of proof are helpful. If you're having trouble getting an exhibit in, ask the judge to make an offer of proof. Again, connect it to the evidence. Maybe you need a memorandum of law. Maybe you just need an argument on the record. And finally, don't forget that the courts can take judicial notice of certain facts, court orders, and records. You don't necessarily need to, if there's a prior order, you're moving for contempt, you can ask the court to take judicial notice of their original judgment of divorce that the party is in contempt of. Okay, let's go on to voir dire. Voir dire of the expert, when to do it, why to do it, and how to do it. Voir dire is simply French for Voir dire, I don't really know exactly right now what that means, voir dire. Voir dire is the questioning of an expert. It is to question them, to flesh out their background, their curriculum vitae, their area of expertise, and to get the judge to agree that this person is in fact an expert and therefore I should listen to them. Experts are not automatically going to be accepted by a court unless they pass the test. And the test is, I spelled it out there for you. They're used where there's reason to suppose that such testimony that this expert is going to give will elucidate, will educate, or shine light on some material aspect of the case that would otherwise resist, I love the language, resist comprehension by the fact finder. Just a nice way of saying the judge knows nothing about this area and we need an expert to come in and explain it. Maybe we know nothing about the area. In matrimonial cases, most of our experts are used predominantly on issues of business valuations, financial forensics, or psychological forensics in custody cases and things of that nature. In other fields, they're used in civil litigation extensively. Many years ago, I had a case involving a elevator that malfunctioned and fell, and we had to get an expert on elevators. Something that, a judge or I don't really understand how they work, nor would an appellate court. So voir dire is simply questioning them. Okay, well, first thing you have to ask is whose expert is it, and do you agree or disagree with their position? We all know in matrimonial law, it is very common that we will mutually, both sides, if we know we want something valued and we trust someone to value it, like an appraisal on a house, we're going to say, okay, look, we both know Joan Smith and we trust her valuation, or we know Bob Burns and we trust his accounting capabilities to look at these records, and we'll stipulate to use that person. And whatever report they come out with, again, could be subject to cross, but we're going to agree to use that expert for some reason. But do you agree? If you agree with the position, you can just stipulate to put their findings into evidence or their report into evidence. If you disagree, that's where this becomes a bigger piece. If you agree with the witness, maybe they're not even called because you agree with the report, but if you don't, they're going to testify. You might not need much voir dire, especially if the court is very familiar. Bob Burns has testified 50 times in this court. Or if there's a need to highlight perhaps something they don't know enough about. Bob Burns is a really good expert when it comes to valuing used car businesses, but he doesn't understand the massage parlor business. Two completely different businesses. So yeah, maybe we're not going to be able to keep him out to testify, but we do want to highlight, gee, how many massage parlors have you ever valued? None. And just get that on the record, even if for appeal purposes. There are sample voir dire questions provided in the materials we've given to you to question an expert. If you know the expert's going to get in, you may just want to stipulate and not let the judge hear the litany of how wonderful and experienced and loved this expert is. Yeah. I stipulate to him and kind of bypass that. Okay, let's go to trial objections. I think we're doing good on time. The most common ones and how to use them. To testimony. Let's start with testimony. Obviously, hearsay is the biggest one. I'm not going to sit here and run through all the hearsay exceptions that we learned in law school, but don't forget the basic definition. Most people mess up on their hearsay objections, not because they don't have the right one, but they don't understand, again, hearsay, it has to be an out-of-court statement offered into evidence for the proof of the statement by the declarant. So obviously the parties can say what each other said because they're both there, but your client can't say, my sister-in-law told me. Okay, that is hearsay. That's your basic definition. I have a case here about some areas where it is admissible if it's demonstrated that it falls within one of the hearsay exceptions. We all know that, but be aware the burden is on the party objecting to the statement to come up with why they have that objection. You don't just say objection, you have to say objection hearsay, and be ready that if the judge says to you, what is the hearsay basis? You gotta come up with it. It may be so obvious that a judge is just like, yeah, it's hearsay. But if it's not so obvious, be ready to know your exceptions. Okay, other standard testimony. This is not physical evidence. This is testimony objections. Compound questions. Where and when did you do X? It's compound. It's asking for when and where. Not every question that's a compound question should be objected to. Think carefully about how much objecting you want to do. If it's a trivial, even if it's a hearsay question, if it's trivial, it's not going to hurt your case. It's something that you know is going to go in. You may want to let it slide just to keep the trial moving. You don't want to be one of those obnoxious people that objects every second. On the other hand, as we'll talk later, you may have a strategic reason to do it. An argumentative question. But you lied when you said it's argumentative. It's not a question. Leading, obviously, we know. Didn't you tell so-and-so X? It's okay on cross, just not on direct. And again, the court will give some leeway for leading directions on leading questions on direct, like you were married May 6, 1990. It's leading, but yeah, I mean, it's a basic question in a divorce action. Okay, assuming facts and evidence, we all know that. When did you stop beating your wife? Well, if we haven't proven that I beat my wife, then it's assuming facts, not in evidence. We all know that one. Asked and answered. There are some attorneys that if they don't get the answer they want the first time, they ask the question a different way, which is okay. But after repeating, and clearly not getting an answer, it becomes abusive. Asked and answered. Speculation. Wasn't your spouse simply trying to X? Speculation. I don't know what they were trying to do. I don't know what they were thinking. You ask facts. Relevance. How old is your cat? Might have nothing to do with the case. It might not. Privileged. Obviously, we know those. Did you tell your doctor X? Did you tell your therapist X? Unless that privilege has been waived, or it's the party has put their mental health condition in evidence, it's a custody case, and there's a reason to go into that. Those obviously, priest penitent and doctor client, lawyer client, doesn't apply. No, where it doesn't apply. Doesn't apply to accountants, your tax accountant. That's not privilege. So make sure if you're going to raise that privilege objection, you have the right connection there. Okay, and I had listed here a family court case regarding custodial objection, but since we're not focusing on family court, I'll just let you take a look at that case if you need to. It has to do with where cases overlap with Article 10. All right, objections to evidence. So save your objections for what you really need to keep out. Don't just raise them all the time. Failure to lay a proper foundation. The documents admitted have not been admitted pursuant to subpoena. They've not been certified. They weren't produced by your opponent or by you. And you have a reason to object to the foundation. Someone just hands somebody a text and there's nothing identifying it. No foundation has been laid. Lack of authentication, that primarily goes for business records. Relevance, again, is the document relevant to the issues before the court? The evidence is inflammatory. We see this a lot in criminal cases where someone wants to show gruesome pictures of an injury or an accident or something like that. If the evidence is inflammatory, we all know is it more probative than prejudicial? Does it move the facts of the case forward for the fact finder, or is it just meant to make somebody look really bad and it's not necessary? More prejudicial than probative is what we're looking for. All right, we talked about privilege, know the exceptions, best evidence rule. Again, the best evidence rule, we already talked about that. That's the one where the original needs to be produced because the document is in dispute. Okay, and then why object, why not, and how? Obviously, if the evidence is going to harm your case, you have to object. Even if you know the judge is going, don't tell your client, I'm not going to object because I know this judge is going to overrule my objection. You make it anyway because you may have an appellate issue. If you have not raised the basis for the objection on the record, it's going to potentially negatively affect the appeal. So if I object to a piece of evidence and the judge overrules, and I don't make an offer of proof, Judge, I'm objecting because I may not have preserved that issue, because the appellate court will say, well, there's an objection, but not knowing the basis for the objection, we can't say whether or not it was valid. So preserving issues for appeal is really important. But be aware that objecting too much could draw attention to something that you really want to minimize. The woman protests too much, from Shakespeare. You do protest too much, you draw attention to it, you begin to raise the judge's concern about why are you so anxious to keep this issue away from the court. Again, stating the basis for the objection, I just mentioned that. And the last reason to object, and I don't suggest this as a regular thing to do, but many lawyers will do it to throw off an unprepared witness. So there's two sides to this. If you have well prepared your client and your witnesses, this will not be a problem for you. If, however, you get to court and you see it's very clear that the other side has not prepared their client or their witnesses, you might want to throw a little bit of tar in their feathers and get them razzled a bit, interrupt the case a bit, shake up the witness. Many years ago, I saw a trial where a witness was really not prepared. It was very clear the witness wasn't prepared. And after half a dozen questions and half a dozen objections, all being sustained by the other side, the judge just said, let's take a break, put the parties out in the hallway, and the case settled, because it was clear the party going forward on that case was their client wasn't prepared and it was going to be a disaster. And the judge was wise enough to know that a settlement would do this side much better than moving forward with the trial. Okay, and then the last slide is preservation of issues for appeal. I've touched on some of this as we've moved through some of this material already. If you have prepared your case from the start, you know from the start, I've got this separate property or this transmutation issue that's going to be a big deal. I've known it from the start. My discovery has been framed around it. My evidence and testimony at trial has been framed around it. My preservation on the record by objections has been framed around it. You should be okay if an appeal goes forward. We know most people in divorces, unless it's an issue of significant value or involves kids, does not go forward for appeal, but some do. And that's what you have to be ready for. Your job is to protect your client under the law. So that means being prepared for that. Be aware of what those issues are going to be, and you'll be prepared if the appeal comes up. Note that the appellate courts may not know who the experts were that you used in a case. And that may be a reason why, even though the trial court knows your expert and you didn't want to voir dire and put their history in, maybe knowing that this expert's standing is going to be impressive to an appellate court, and this is the issue that I know is probably going to go up on appeal, you want to put all that stuff in. You've thought this through. So you know when you put your expert on, you did specifically put in their qualifications and allow the other side to voir dire them. Objections, again, there are cases out there where just objecting but not stating the basis, the appellate courts have said, we can't rule on this because we don't know what the basis for the objection was. And you can't make the appellate court do that work for you. Note the timeliness of an appeal. Most attorneys who do matrimonial trials, most of their retainers are limited to the trial work. They don't necessarily involve the appeal. They don't necessarily do the appeals. But just because you may not be retained for the appeal, if your client tells you that they want to appeal the case, you may still be obligated to, if not filing their notice of appeal for them, at least putting them on written notice. Here's the decision of the court. It's been entered. You have 30 days if you wish to file a notice of appeal. As you know, we don't practice appellate work. I refer you to, so-and-so or call the Bar Association, but cover your tail and make sure that you have something in your file that indicates that you have put the client on notice of a time limit, because those are strict time limits, as you all know. What orders are appealable? Make sure you know which orders are appealable and you have advised your client. filing of the notice and the pre-appeal statement. Those two have to go together. Where to file the notices, fees to pay, and if you do file a notice of appeal for your client, but you're not going to perfect the appeal, cover your tail. Make sure that's in writing. We have filed the notice of appeal for you, however, to preserve your rights. However, we are not perfecting the appeal. Tell them what that means. They don't know what perfecting the appeal means. Give them a time limit and let them know, and cover your tail, saving that in your file. All right, so that's the basics start to finish, and I think we have time for some questions.
I'm actually going to read the second course code, but before I do that, if anybody has any questions for Barbara, please submit them via the chat and I will send them over to her. The second course code for today's presentation is 681297. Again, that's 681297. And then we'll just let everybody submit any questions if they have any. So we'll give you guys a minute.
Okay, I have one. Can a court require you to have documents produced on your subpoena request to be sent to them? Yes, a court can direct, if you have to make a motion for subpoenaed records, a court could direct that they be sent to the court. I mean, normally if they're the subject of a motion, they will be sent to the court when produced. And some records are very sensitive and the court doesn't want them sent elsewhere, but the court can require that they be produced to the court. They're usually sent to the clerk's office, and then the parties can just go down to the clerk's office, identify that they're a party to the action, and get access to the records.
Barbara, I believe those were all of the questions that were submitted. If you have any closing statements.
No, I just hope this is a good refresher for folks, and that some of what we've learned over the years of making mistakes ourselves has resulted in being able to give you some tips to help you moving forward. So thank you everyone for attending.
Thank you everyone again for joining today's presentation, and thank you Barbara for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you and have a good rest of your day.